Hello, I am Tony Vernetti, the President and Founder of FEDS, Federal Employee Defense Services, a professional liability insurance company serving the entire federal employee community. Thank you for attending today's informational webinar on professional liability insurance for federal employees. Before we get started, I would like to give you a little information about myself. I am a former federal employee myself. I was an attorney for a federal law enforcement agency for many years before going into private practice. And then I worked many years defending federal employees at my old law firm, Shaw, Bransford, Vayu, and Roth, where I was a partner and did legal work for a similar liability insurance company. I founded FEDS on a foundation of one of education, because during my law practice, I was constantly amazed at how few people knew about the liability insurance. I can't tell you how many times I had to take $20,000, $50,000, even $100,000 from federal employees to defend them, to protect them. If they would only have spent the $135 a year, which is all the insurance costs after the reimbursement, they would have been fully covered. So it is my sincere hope today to provide you enough information and education on professional liability insurance so that you can make an informed decision for yourself. Today you will learn about your administrative, civil, and criminal exposures you face as a federal employee. You will learn about the professional and financial risk associated with your federal employment. You will learn what to do upon the notification of any allegation, inquiry, or investigation. You also hopefully learn how professional liability insurance works and the coverage it provides. We're going to start here with a little bit of a history lesson. Liability exposure for all federal employees really began back in June of 1971 with this decision. This Supreme Court decision called Bivens versus 6 unknown federal narcotics agents, which is the precursor agency to the DEA. In this decision, the Supreme Court first allowed federal employees to be sued personally. This is not law school, so I'm not going to get into the factual facts and the legal analysis. All you really need to know is that federal employees can be sued personally and they can be liable for monetary damages. The second thing you need to know is that while you do not have absolute immunity for these personal capacity lawsuits, you have qualified immunity for these personal capacity lawsuits, which is still pretty darn good. Qualified immunity essentially means that you will not be held liable if you had a good faith belief that your actions were legal and your belief was a reasonable one. But because there is this possibility that a federal official could be liable for doing his or her job, the idea for professional liability insurance came about. And this is also the very reason that Congress passed legislation requiring federal agencies to reimburse managers, supervisors, and law enforcement officers up to 1/2 of the cost for the liability insurance. Now, this official support for liability insurance really demonstrates Congress's understanding that there are risks associated with your federal employment that they cannot completely cure with legislation or other action. It is Congress's belief that PLI, professional liability insurance, is necessary for certain groups: managers, supervisors, and law enforcement officers. They feel that this is necessary for you to have peace of mind so that you can make the tough decisions that are part of your federal job. It's also important to note here, because I always get questions about this time as to whether other non-manager supervisors, non-law enforcement, non-intelligence agency personnel, whether they are eligible for the insurance. Every federal employee, full or part-time federal employee, is eligible for the liability insurance. Whether you are eligible for the reimbursement, you should check with your agency and the policy that they have promulgated regarding the reimbursement legislation. It is designed to be very liberally interpreted, so even though you may not view yourself as a manager or supervisor, you may still be covered by the legislation. Here we put together some categories of federal positions, federal jobs that we have identified as primarily needing liability insurance. Because the potential liabilities that exist and the reasons for which federal employees purchase liability coverage can be different depending upon the type of job you have or you hold in your employing agency. These are the major categories. For example, a firefighter, you will find, may need liability insurance for strictly administrative and criminal matters, whereas a manager and supervisor may really only need it for administrative matters versus law enforcement, intelligence community really needing it for all three. Here are the laundry list of positions. It's just an example of the many positions that we have identified as having professional exposure and needing professional liability insurance. If you don't see your position or something similar, it doesn't mean you don't have professional risk. It just means that we have not yet identified it. Moreover, as you can imagine, it's hard to identify every possible scenario and position in the federal arena. This is meant to be a sampling. And again, the reasons that federal employees need liability insurance are slightly different for each and every type of position that you see here. And I would encourage everyone who is listening today after the webinar to also get on our website at www.fedsprotection.com, FEDS because for each of these positions that you see here, we have a separate page on our website that really explains, hopefully in simple terms, exactly what the liability insurance provides for you and why it's necessary. Here I would like to just start with a general overview of what the liability insurance provides. You should always think of liability insurance in three separate categories. It protects against civil, administrative, and criminal exposures. So the civil first. You can get $1 or $2 million of indemnity protection in the event you are sued and found liable for what's called a personal capacity lawsuit, commonly referred to as a constitutional tort or Bivens action. I call this the pocketbook part of the insurance, because this is where you can actually be liable for monetary damages, significant financial monetary damages. So you don't have absolute immunity for personal capacity lawsuits like you do for lawsuits under the Federal Tort Claims Act, FTCA. More importantly, the Fed's policy will appoint you an attorney to defend in these personal capacity lawsuits if DOJ exercises its discretion not to defend you, okay? That's an important concept. It is DOJ's discretion as to whether they will defend you. And this is whether or not you're acting, it's notwithstanding the fact that you are acting clearly within the scope of your employment. They most often answer that question in the negative, meaning they won't represent you. If you are being investigated for some sort of wrongdoing for the very same reason that you are being sued, you can clearly see that DOJ will not want to be on both sides of that case. The additional thing that the policy provides for the civil coverage is that we may appoint coverage counsel to essentially monitor DOJ's defense of you in particular cases. Also, if DOJ, let's say, is on the fence as to whether they will enter an appearance and represent you or not, we may hire coverage counsel for you to convince DOJ to provide the legal defense for you. Because after all, we're in this together, we're in this with you, and we're all better off if the United States government is in court representing you. So that's what we like to encourage. So that's the civil part of the policy. The overview for the administrative part of the professional liability policy is that it provides legal defense up to $200,000 for any disciplinary investigation, judicial sanction, any administrative investigation, any investigation into alleged misconduct, anything, any type of investigation that can result in an action against you. So whether it's the OIG, Office of Inspector General, OPR, Office of Professional Responsibility, OSC, Office of Special Counsel, Congressional, someone files an EEO investigation, an EEO complaint against you, and you are the responsible management official, any internal management investigation whatsoever, we will provide you an attorney, what I call cradle to grave, from the start of the investigation, and in the unfortunate event that there is an actual disciplinary action imposed against you, such as a suspension, removal, reprimands, we will provide an attorney to defend both at the agency level, and if you have an appeal to the Merit Systems Protection Board, the insurance also provides a defense up to $200,000 for those appeals as well. And finally, coverage. The Fed's professional liability policy pays for legal defense up to $100,000 for any criminal proceeding or investigation into any act, error, or omission committed by a federal employee while rendering a professional service. There is very little that you can do wrong in the federal government and not also have it be a violation of the criminal code. Remember the Martha Stewart trial? There was a Secret Service agent that testified against her in the government's case in chief. DOJ turned around and prosecuted that agent for perjury because the DOJ felt he lied in his testimony. That agent had professional liability insurance, was appointed competent counsel, and actually was eventually acquitted at trial. And there are numerous other criminal examples that we will give you later in today's presentation. Last but not least, your liability insurance also gives you 2 free half-hour legal consultations for pre-complaint matters. These are things that are not quite complaints yet, or items that are a little bit outside of the scope of what the coverage would apply to, such as if you had a question about workers' comp, disability benefits, something of that nature, we'll get you assigned to a lawyer to answer those questions. So let's start with civil suits. Here's a nice picture of a courtroom where none of us ever want to be. Civil suits, I will point out, are most common against federal officials for law enforcement officials, managers, and other federal employees who have day-to-day interactions with the public or other type of regulatory oversight. It doesn't mean, these concepts that we're going to talk about, will still apply for any type of suit against a federal official, but I do want to point out they're more common to those particular groups of employees. Civil suits, as we talked about before, are commonly referred to as Bivens actions, constitutional torts, or individual capacity lawsuits. Okay? All you really need to know is that you are the named person in the personal capacity lawsuit. So we're going to go over some concepts here that are very important. We're going to go over representation, who defends you, immunity, the central thing you would use to defend yourself, and indemnification. If you are found liable, how can you how can you pay the judgment either through the insurance or if the agency provides indemnification. We're going to talk about those concepts. So the first thing to understand is that DOJ representation is not mandatory and it is not automatic, okay? It is the sole discretion of DOJ to decide whether you will be assigned a DOJ attorney to defend you. Even if it's absolutely clear that you were acting within the scope of your employment, DOJ must also determine that it is in the interest of the United States to provide you with defense counsel. That is the two-part test. I often get questions, what does the interest of the United States mean? Well, it means whatever DOJ wants it to mean. Also, in the representation arena, as I mentioned before, we will assign, in certain cases, particularly big public media sensation type cases, we may assign coverage counsel to kind of oversee what DOJ, how they are defending you, because remember, even if DOJ is in the case, they said it's in the interest of the United States to defend you, and they lose, it's still a loss against you. You could still be liable, okay? So the insurance is important for that, so it's important that we appoint coverage counsel in certain cases to protect your interest and ours. The thing that I would just like to emphasize here, with hourly rates for attorneys running anywhere from $250, $300 to $400, $500 per an hour for an experienced lawyer that really understands these types of civil lawsuits, the bills can run up very, very quickly. Even if your allegations are ultimately disproved and you clearly claim qualified immunity to get the case dismissed, you could still be faced with paying significant legal fees if you did not have the liability insurance. The next concept I want to get into is you don't have absolute immunity under the Federal Tort Claims Act for common law torts. That's another way, saying if you're sued personally, the FTCA does not apply. Okay, if you were sued, for an FTCA matter, what the government would do is they would substitute itself for you. Okay, because that type of lawsuit, FTCA lawsuit, can only be filed against the government. If it's a personal capacity type lawsuits, what we call common law torts, these constitutional torts, it is a lawsuit against you, and you only have qualified immunity. And we explained earlier, what that means. The next concept I want to talk about is indemnification, liability. Even if DOJ provides representation, what you need to understand is that it's still a lawsuit against you personally. So you could still be liable. The requirements for indemnification are scope of your employment, and is it in the interest of the United States to indemnify you? And does your agency have regulations governing the indemnification process? If all those are yes, and the agency agrees to indemnify, that's wonderful. The judgment's entered against you, and then they'll pay it out of there. It's important to know that you can't get pre-decisional indemnification decisions from your agency or Department of Justice. So it's a little disconcerting to have to wait until to see if you lose the case and then go ask the agency whether they're going to indemnify you or not. So there are cases that have gone to full trial, federal employee is found liable, and the government has not indemnified. Particularly if you're one of the unfortunate individuals who has not been represented by DOJ, meaning that they've already said it's not in the interest of the United States to represent you, they're not going to turn around and say it is in the interest of the United States to indemnify you. So that's where the insurance is very important. You have indemnity protection, civil liability protection up to $1 million and $2 million limits to pay out that judgment. So just a real quick overview here of what the liability insurance provides for civil lawsuits. It provides for the legal defense. It also provides coverage counsel, and it pays damages. So here are some real good examples for actual lawsuits that have been filed against federal employees personally. Everybody remembers Waco and the Bivens lawsuits that flowed from there. Several ATF agents and I believe FBI agents were sued personally. The Elian Gonzalez lawsuit case down in Florida, where they had to essentially seize young Elian and been able to reunite him with his birth father back in Cuba. There were personal capacity lawsuits that resulted against the agents who were involved in that raid. Some other ones that you may not be you probably haven't heard of, prisoner lawsuits, any these allegations of sexual harassment resulting from official but realistic street chaining for law enforcement resulted in a big lawsuit. These are real cases. Okay, this is why we put these examples up here for you. If I didn't mention, those previous examples were primary examples for law enforcement officials, which is where we do see the bulk of civil lawsuits being filed against federal employees. Here are some good examples for civil lawsuits being filed against managers. A manager who was sued personally for searching a subordinate employee's desk drawer. In this case, it happened to be a desk drawer that was locked, and the manager cracked the lock. And what the court said, or what the pleading said, is that employee, while they don't have a complete expectation of privacy in everything in the workplace, they did for that particular locked desk drawer, that the employee did have a reasonable expectation of privacy. So the allegation was that the manager violated his Fourth Amendment right. This case up here at the top, the federal employee who was fired during his probationary period, that is a very, very recent case, Library of Congress case. It involves a new federal employee who actually was a retired military officer who was the head prosecutor down in Guantanamo Bay, and he resigned in protest, military commission. He resigned in protest over the way the prosecutions were being handled at Guantanamo Bay. And then he sort of became a poster child for that and did a lot of writings, New York Times articles, blogs, and was out there a lot talking about his experience and being very critical of some of the administration's policies that were going on in Guantanamo Bay. He gets another job. He gets a new job with the Library of Congress, Congressional Research Office, and Library of Congress has rules, because it's the Library of Congress, on what you can publish. And the manager in this case told the employee, probationary employee, that he felt that his writings, what he was publishing, one in particular that he was getting ready to release, he felt that that was in violation of the Library of Congress's rules, that the employees can't publish anything that reflects unfavorably upon the agency. The probationary employee published the thing anyway. The agency fired him. Okay? The employee sued, and the court allowed a personal capacity lawsuit to go forward against the manager, or at least discoveries going forward against the manager for violating that employee's constitutional right to free speech, the First Amendment. Okay, so this is a case we all, have our eyes on. It's currently, up on appeal. I don't know how it's going to come out, but it does highlight some real-world examples where liability can be held against federal officials for simply doing their job. So again, a recap for civil capacity lawsuits. Representation, what you need to know is DOJ can deny representation. So the insurance gives you that insurance that you will have representation. Immunity, you can be sued, okay? You can be sued. You can indemnification. You can be liable for the judgment. So the insurance also provides that peace of mind that it will pay for the judgments if you're one of those cases that slipped through the cracks. So that's it for civil, the civil part of the policy. We're going to shift gears here a little bit into what I call the administrative expense provision of the policy. Here are a list of several types of investigative bodies that will conduct investigations. OIG, Office of Inspector General, OSC, OPR, Congressional, HR investigations, EEO matters. What I want to emphasize here, what everyone needs to appreciate, is that complaints and allegations of wrongdoing against federal officials is simply the cost of doing business these days. And they can be made by anyone, members of the public, managers, subordinates, disgruntled employees, the employee that you're trying to manage, trying to get a day's work for a day's pay, who's complaining, even politically motivated elected officials. Investigations can start at the drop of the hat. Okay, so it used to be, I would say out there, a federal official could go 20 years or so, and even their whole career, without having to be subjected to one of these investigations or having somebody file a complaint against them. Now it's really every 5 years or so. Okay, and whether the allegations are true or false, just the way we have all this transparency in our government, no matter how outrageous some of these allegations may be, most agencies feel that they are required to determine the validity of the allegations, so they're going to investigate everything. It's like the old adage where folks said you can criminally indict a ham sandwich. The federal government is investigating ham sandwiches. So what does the coverage provide for these administrative and potential disciplinary matters? You would be assigned an attorney, as I said, to defend you against the allegations. And this means prepare you for the agency administrative or investigation process, attend the investigative interview with you if you are allowed. It is discretionary at most federal agencies whether a lawyer can come in with you for the investigative interview. But even if a lawyer is not allowed in, you can really benefit from being adequately prepared for that administrative investigation. The idea is the first time you hear a question, or the first time that you thought about a question, should not be that day that you walk in for your investigative interview. The insurance also provides defense and disciplinary actions, both at the agency level and at the MSPB. So this is just an overview in case you're unfamiliar with how the federal sector disciplinary process works and the due process that you are entitled to, and then also really how the liability insurance applies every step of the way. So again, any sort of administrative disciplinary proceeding is going to be based on the investigative findings, the investigation. or we call the ROI, report of investigation. So having a lawyer during that investigation phase is going to be in your best interest. You know, we always say you want to have the lawyers involved at the earliest possible stage and have them closest to the problem in order to properly advise you. The next stage, if there is action the agency wants to take, is because you are a federal employee, you have rights, so they can't just take the action. They must propose an action and give you an opportunity to respond. It gives you an opportunity to review all the evidence against you, and it gives you an opportunity to respond in writing and orally, what we call an oral reply, an oral presentation. And if you had a lawyer, if you had liability insurance, this is what your lawyer would do for you. This is a significant, important part of the process, okay? This is, you know, what I call, you know, I often will get calls, people very upset. They got to propose 30-day, propose 40-day, propose removal, and, you know, they just don't know, you know, what they can do. You know, I always calm them down and say, look, you get due process as a federal employee, okay? And I still, to this day, put my trust and faith and confidence in the federal government to get things right and do the right thing. So it's at this proposal stage that it's your opportunity to show them that they got it all wrong, that they misinterpreted the evidence, that they didn't consider this factor, this factor. It's your opportunity to go get evidence to rebut the charges. This is the most important part of the stage for you to turn back any disciplinary action, and it's very important for you to hopefully have a lawyer assist you with that. The next stage is if there is a letter of reprimand or a suspension of 14 days or less issued against you, you have the right to challenge that through an agency grievance procedure. And again, a lawyer can help you with that. The insurance would provide a defense for that additional appeal. Also, if you have what's called an appealable action to the MSPB, that's a suspension of 15 days or more, demotion or removal. The insurance provides an appeal to the MSPB. And that's essentially, if you're unfamiliar with it, it's like going for a bench trial. It's an administrative, judicial function the agency is set up to adjudicate these federal personnel matters. It's just like a real court. There's depositions, there's direct examination, cross-examination. It is a real, true legal proceeding. You're obviously going to be much better off having legal counsel. Okay, as I mentioned, this is an educational, informational seminar, so I would like to give just a little bit educational information on IG investigations here because they're very, very serious. Essentially, there are 73 statutory IGs. Most agencies have one in some form or another, and they are what's called the agency's independent watchdog. They investigate any allegations of fraud, waste, and abuse, and any allegations of wrongdoing by federal employees or other federal officials and contractors. Okay? Why do you need a lawyer in these types of investigations? Because there are some very important constitutional implications to the way the investigations are being handled. Okay, one of them is it a voluntary request for an interview or compelled? All right, what does it mean if it's voluntary? It means just that, it's voluntary. You do not have to participate. If it's compelled, you do have to participate. But what that gets you, and most lawyers want the interview to be compelled, because what that gets you is something that's called use immunity. Okay? The IGs typically are going to start any investigation off to see if there's any criminal allegations here, okay? And then it may shift towards more of an administrative function as they learn the facts. But because there's a potential for the IG to conduct a criminal investigation, you're far better off having what's called a compelled type interview or what's called a Kalkine's warning, so that anything you say cannot be used against you in a criminal matter. Okay? These are important, very important concepts to identify with the IG up front. And, you know, the IG is not your friend. You know, and in my opinion, the day is long gone where IGs see it as part of their job to clear federal officials of wrongdoing. Rather, they want to make cases. They want to do their job. You know, they sit in judgment, you know, of people all day. You know, this is not to say that their role in the federal government is not very important, because it is. It is just that I've seen a trend of the IGs trying to make cases at all costs, investigating matters that are well above and well beyond the original allegations, essentially investigating everything and sort of see what sticks. And I'm here to tell you, when the weight of the federal government puts that magnifying glass on you, none of us are perfect. So I say that so that you take these IG inquiries, investigations very seriously. You get the legal advice that you need before you just walk into them, and hopefully you have the liability insurance, because it will provide you a defense. And most IGs, I should mention, let lawyers into the interview, into the investigative interview, whether it's administrative or criminal. It's still discretionary, and they're there in an advisory fashion. You still must give the testimony, but most of them allow attorneys in, and it's been my experience that most of them prefer to have lawyers involved in the process, and it doesn't connotate any sort of presumptions of guilt. You know, if you quote lawyered up, you know, I think IGs appreciate that it allows for, you know, a much more comfortable interview setting, because the employee has already been advised by his or her own lawyer what their rights are, you know, and what their responsibilities are for this type of investigation. Another serious type of investigative entity that you may encounter out there is the Office of Special Counsel. The Office of Special Counsel, or OSC, is an independent federal investigative or prosecutorial agency. Its basic authorities are to investigate whistleblower retaliation, whistleblower disclosure retaliation type complaints, any prohibited personnel practices such as pre-selection, other things that violate the merit principles. They also are responsible for enforcing and regulating the Hatch Act, that's political activity for federal officials, and something called USERRA, the Uniform Services Employment Reemployment Act, essentially veterans being called up to active duty, having certain rights to be returned to certain positions and benefits when they come back. Again, you're typically allowed a lawyer in to these types of investigations. And the other thing that I want to emphasize here, and I'll emphasize this later when we talk about EEO and RMOs, is the agency, when OSC comes in to investigate, it's investigating you and the agency. It's going to ask the agency for a bunch of documents. And your agency may actually assign you a lawyer to assist and to attend the investigative interview with you. That's a good thing, but you do need to appreciate that that lawyer's duty of loyalty is to the agency. Their client is still the agency. It's not you. The duty of loyalty is to the agency. So there's a possibility they could be adversing a position that is adverse to yours. So it's important to at least consider having your own lawyer during these OSC type investigations. The other investigation type that I want to mention is something called OPR, Office of Professional Responsibility, and we see this in mostly federal law enforcement agencies or Department of Justice, other type of prosecutorial attorney-based agencies. And these are the typical allegations, that we see. Most AUSAs, Assistants United States Attorneys, federal prosecutors, are familiar with, allegations of abuse of prosecutorial decisions, Brady violations. They know that that's going to result in an immediate OPR investigation. Same thing with my federal law enforcement officers, whether you're in 1811, 1801, or forming some other law enforcement function. There's a credible amount of scrutiny associated with your job, and we often see investigations in that regard. The insurance also protects you for congressional investigations. It's important to know that it's not just politicals, all right? It's not just politicals that become the target of a congressional investigation. It can be the career employee, and sometimes I've even seen it where the politicals serve up the career employee. So, it can come in the form of a request for testimony, subpoena. It's just very important to have legal representation, during this process because the stakes are high. It also covers commissions and other hearings, like some of you may recall the 9/11 hearings. Again, any HR-directed investigation that could result in an action against you, you're going to be covered. And for my lawyers out there and other professionals, it also covers you for any professional misconduct matters that arise out of you performing your federal job duties. So let's say you were a lawyer subjected to a DOJ OPR investigation and they conclude there was some professional misconduct. They have to refer that to the state where you're licensed to practice law, and that may result in a state proceeding against your license. The insurance provides protection for that. That's the classic legal malpractice type insurance. Same thing for medical professionals, doctors, nurses, and any other professionals that are required to be licensed, such as, accountants and other type of financial matters that are regulated, and it's a part of your job to have those certifications. EEO complaints. If you are a responsible management official in an EEO complaint, you are entitled through the insurance to have your own lawyer to advise you, okay? I am often asked, why do I need liability protection for EEO complaints filed against me? I thought that's a case against the agency, all right? I thought the agency lawyers defend that case. Well, the answer is yes. It is a case against the agency, okay? It's not a case against you personally, even though you're alleged to be the responsible management official. But we cover it because discipline can flow from that. In the wake of such laws as the No Fear Act, where there are special reporting requirements on findings of discrimination, special emphasis on disciplining managers, offending managers, and other employees when they are found to violate the fair employment laws or whistleblower protection laws. We're seeing an increased scrutiny, against the management official in these cases. Therefore, we feel it's very important for you to consider having your own attorney just give you some advice, particularly during the investigation process. Because just like the Office of Special Counsel example I gave you, the lawyer that's going to be assigned for the agency, they represent the agency. Your interests may be aligned, but their duty of loyalty is to the agency. There could be a point where your interests are no longer aligned. So you may want to consider having a lawyer look out for your own interests in that case. And more importantly, I've often found throughout my law practice when I've talked to managers and other employees who are involved in these EEO matters, is no one really explains to them what their role is in the process, okay? Through the insurance, we'll do that. I mean, your role is to put forward, to make a record of something that's called the legitimate non-discriminatory reason for doing whatever you did or did not do. That's what the agency is going to use to defend its case against the government, that legitimate non-discriminatory reason that you put forward. So it's very important that you put that, you make a record of that in the clearest and the most concise way that you can, and a lawyer can certainly help you do that if you have the insurance. So here are some great examples of covered administrative actions for most federal employees. I love starting with the federal veterinarians because most people who are unfamiliar are surprised that we even have federal veterinarians. You know, what do they do? Well, you know, they supervise and regulate the processing of you know, of our meats and agriculture items as well. And just like any professional employee, they could be subject to disciplinary action if they're found to violate some very strict and sometimes nuanced regulations. Okay. There's an example here of Congressional Oversight Committee, where targets managers, you know, who made decisions about certain programs, you know, or personnel decisions, or it's just perceived by Congress that they were making those decisions. Again, these are real cases that I put out here. You know, we've changed the, you know, the face of them a little bit to protect for privacy reasons, attorney-client reasons, but these are real cases. Just want to give you a little bit more time to read those. This is a big one, the manager accused of sexual harassment, because also not only, you know, can you be, in that case, the subject to a, you know, responsible management official, like I just talked about in the EEO matter, for specific liability reasons, agency liability reasons, they have to investigate any allegations of sexual harassment, notwithstanding whether the employee filed an EEO complaint or not. And they need to do it immediately. So, you know, when there are these allegations, managers usually reassigned, put on administrative leave, and they come in and they investigate, you know, within 48, 72 hours. And managers are usually very shocked, upset. You know, they patently deny, you know, the allegations, but they just, you know, appreciate that the agency needs to come in. This is the process, and do its investigation so that they can unsubstantiate the allegations, or in the unfortunate event that they are substantiated. It's certain what we call in the law is a Farragher and Ellerth investigation, which is essentially just two case names. Here are some great examples for law enforcement officers. You may ask why law enforcement gets its own slide. Well, that's because they get in the most trouble. And I believe that is because they have the three toys. They got the gun, they got the badge, and they got the car, they got the GOV. And the allegations of wrongdoing usually stem from something having to do with those three. Well, that concludes our administrative portion of the presentation, and now I want to segue into criminal investigations. And I love this slide because you can see if the IG or somebody showed up in your office and said, "Hi, I'm so and so. You are the subject of a criminal investigation," or if you get a target letter from the Department of Justice. Okay, you can see how shocked and angry, you know, and upset you would be. I can't believe this is happening to me, okay? And it may be for something that was unintentional, okay? There are a lot of crimes in Title 18, which is the Federal Criminal Code, that do not have intent as an element, okay? This is why I say there is very little that you can do wrong in the federal government and not also have it be a violation of Title 18, which I mentioned is the criminal code. If you are notified that you are the subject of a criminal investigation, it is absolutely important for you to talk to a criminal defense attorney before you talk to anyone, before you do anything. You don't have the luxury of just sitting around waiting to see if they're going to do an indictment or really take this case forward against you, okay? If it's an indictment against a federal official, it's usually game over. They're going to immediately push you on indefinite suspension. That means suspension without pay. Without pay. So if you're notified that you're the subject of a criminal investigation, not only because it's your liberty that is being threatened, but because it can have very serious job ramifications if it's not immediately dealt with and dealt with in an effective way. Even if there's some substance to the allegation, a lawyer can really help convince the Department of Justice that you don't need to be prosecuting this federal official, that there's a whole administrative process that can deal with this. And that also is an important point to point out, to mention that when a criminal investigation runs parallel to an administrative investigation, the matter really invokes some very difficult constitutional things. I remember I had represented some federal wildland firefighters who unfortunately were involved in a wildland fire that got out of control and tragically killed some federal employees. The agency felt that things were mismanaged. They ran an investigation. They wanted to take a disciplinary action against the employee, a proposed removal, and at the same time, the IG ran a criminal investigation for reckless manslaughter against the federal official. So they were pitted between having to deal with this criminal investigation and also having to deal with this administrative stuff. And it's very complicated because any defense that you would give in the administrative matter, that could be evidence used against you in the potential criminal matter. And actually, in that case that I'm talking about, we ended up just negotiating a resolution that involved him resigning from his job. So criminal investigations can involve any number of things. Here are some of the ones we see most often. Conflict of interest statutes, where intent is not a prerequisite to prove the crime. So let's say you're awarding a contract and you award it to a company that, unbeknownst to you, your brother-in-law or another relative works for. That could result in a conflict of interest investigation against you. And that is a criminal, it could be a criminal allegation. Misappropriation of federal funds. Again, you didn't intend to do it, but you may have technically made some mistakes. Inadvertent release of Privacy Act or other statutorily protected information such as 6103 tax information. Those are serious allegations. Providing false or inaccurate information. While those are intentional crimes, as to whether you intended to provide false or inaccurate information is a very intense factual issue. Very intense factual issue, and it's important to have legal representation, again, for any one of these types of investigations. Here are some great examples. I already threw out a few of these. This is not what you signed up to do, okay? But you could still be subject to a criminal investigation. It does happen against federal employees, and particularly in the DOJ case I gave you, where they were prosecuting Martha Stewart for lying, essentially. They felt they were keenly tuned into if they felt anybody on their side was doing the same thing, that they, they had to treat that individual the same. And DOJ, right or wrong, likes prosecuting federal officials. I should say they like. They do it, particularly the higher level, the official, they do it to set an example. While there may be this other administrative part of the side of the house that can deal with it, sometimes they want to prosecute for these violations to set an example for the rest of the government so that they're aware that they need to be very careful and not get themselves caught up in one of these things. So what do you need to know for criminal investigations? It's just a summary of what you really need to know. They're conducted usually by Inspector General's office. It could be conducted by another federal law enforcement agencies such as ICE, Immigration Customs Enforcement, FBI, DEA, ATF. But usually for federal officials, it's the IG, and it's supervised by an assistant United States attorney, federal prosecutor, and things are usually run through the grand jury. There are two types of requests for an interview, voluntary and compelled, and it's very important that you appreciate the difference, and it's very important that you get that clarification from the IG investigator or whoever the investigator is. They tend to play games with this. For example, they will say, well, you're required to cooperate. Okay? That doesn't answer the question as to whether it's voluntary or compelled. So it's very important that you get that nailed down, and obviously a lawyer can help you do that. Fifth Amendment. So when it's voluntary, the Fifth Amendment right to silence is almost always asserted. That's always the starting point. And it's done even by the innocent. And they know that. The other side of the house knows that. The investigators appreciate and understand that you're getting legal advice to do that you want to come in, you want to answer questions, but your lawyer's telling you, to sit tight right now. And again, when the criminal investigation runs parallel to administrative, it just involves some very, very, very complicated stuff. So, just a quick overview on, again, what the insurance, the core insurance coverage is. It provides up to $200,000 in attorney fees for any administrative or disciplinary matters. Any investigation involving you will be covered. Lawsuits, up to $1 million or $2 million to satisfy monetary judgments. Attorney's fees to defend if DOJ declines representation. Also, in certain cases, we'll monitor DOJ's rep of you, and if DOJ is on the fence with their representation, we may hire coverage counsel to convince them to represent you. And as we just concluded, the $100,000 to defend against the criminal charges. Again, with hourly rates, $250 to $400, $500, any of these types of matters, investigations, can cost you a lot of money, okay, a lot of money. When I was an attorney in private practice, I witnessed people mortgaging their homes, depleting all of their savings, simply because they did not have a professional liability insurance policy in place. So one other added benefit I want to mention again are these free half-hour legal consultations for pre-complaint matters, or other issues related to your employment. So let's say you're getting ready to take a disciplinary action against an employee, and while you get your own legal advice in the agency, you're just concerned, that employee is going to immediately file a complaint against you. So maybe you want to talk to one of our lawyers, to make sure you have the stuff documented the way it should be, and that you're keeping records the way you should be. That's a good example. Or if you had questions about, your own EEO case, a disability matter, a workers' comp matter, a travel regulation matter, we will get you assigned to a lawyer to answer those questions. It's a good free additional benefit that we give that some of our other competitors actually charge you extra for. So why do some federal employees not buy liability insurance? You know, it's been my experience that it's just really a lack of knowledge and lack of awareness is a lot of it. Now, none of you who have listened today can claim that now. And the other reason is just a false belief it can never happen to you. You know, I see that. I see that this is the type of insurance where federal employees have to envision themselves doing something wrong, you know, to need it. You know, but that's not the case. You know, I understand you're dedicated civil servants. You're carrying out the federal mission to the best of your ability. The day is just long gone, you know, where you're not going to have a complaint. You're just not going to get through a career anymore and not have somebody file a complaint against you, whether it's a jealous colleague, a subordinate employee, difficult subordinate employee, member of the public, you know, or anybody. It's just happening too frequent these days, too frequently. And here's what it costs. It's only $270 annually, or $370 for the $2 million limit. And if you are a manager, supervisor, or law enforcement officer, you get reimbursed. It's only $135 annually. When you think about what you spend $135 on these days, this is a lot of protection. This is a lot of bang for your buck. You know, it's 35 cents a day, 37 cents a day for the reimbursement. I would also note here that some agencies for the $2 million limit cap the reimbursement at $150, and you should just be aware of that before you decide to purchase. Here's the final slide, and the final point I really want to emphasize is this insurance works like any other type of insurance. You need to have it in place prior to the allegation, prior to having knowledge of the allegation, claim, or suit. Okay? If you don't have your coverage in place, you will pay more for 1 hour with an attorney than you would for a full year of this insurance premium. I can't tell you how many calls I get, you know, between 5 to 10 a week, honestly. People who are calling us after they have knowledge of the allegation. Coverage does not apply that way. You're still eligible for the free consultations, but if it's a very, very serious matter, you're obviously going to end up needing an attorney. So, hopefully I have educated you on professional liability insurance today. I would also like to emphasize there is a wealth of information on our website, and that's also where you can get enrolled. It takes less than 3 minutes, www.fedsprotection.com. Or you can call us. If we haven't answered your question, you can't find it on the website, don't have time to look at the website, just give us a call. Our staff is here 8 a.m. to 8 p.m. Eastern Standard Time to answer any questions that you may have. Or if you don't like to deal with the internet and you prefer to just get enrolled over the phone, or you want us to send you a paper application, give us a call, or you can also send us an email at feds, F-E-D-S, at fedsprotection.com. So that's all I have for today. Thank you, and thank you for your federal service.